some refreshments. My name is Liz Myich. I'm a lawyer with Connecting Ottawa. And before we begin our next session, we'd like to take this opportunity to give you just a brief overview of our project, particularly for those of you who are unfamiliar with our work. So Connecting Ottawa is a project funded by the Law Foundation of Ontario. Community Legal Services Ottawa is the managing agency for us, and its executive director, Gary Stein, serves as the chair of our community advisory group. Our role is to improve access to justice for linguistic minorities, so those who do not speak English or French, and for those who face communication barriers as a result of a sensory impairment or a disability. We achieve this by working in partnership with a network of over 53 community organizations to build the capacity of frontline workers so that they can assist their clients with their legal needs. And this includes case consultations, community legal education, and creating resources and tools on a variety of different legal topics. Our staff team consists of 2 full-time lawyers, so myself and Alexandra, and Gina, who is responsible for all aspects of project management. For more information on Connecting Ottawa, we encourage you to check out our newly relaunched website, connectingottawa.com. It's now my pleasure to introduce our final session, Exploring Vaccines and Employment. So Kath and Daniel are here with us today. We're extremely grateful for you for taking the time out of your busy schedules to provide some insight on this really complicated and emerging topic. Katha Swan is a Toronto employment lawyer who advises and represents federal and provincial employers on all types of employment and labor law issues. Katha focuses on reducing risk, minimizing any potential liability, and crafting practical solutions to the employment issues every business faces. Daniel Chodos is a partner at Witten and Lublin Employment Lawyers, where he advises employers and employees on day-to-day workplace matters. Daniel has litigated cases before the Ontario Superior Court of Justice, the Ontario Court of Appeal, the Labour Relations Board, and the Human Rights Tribunal. Daniel is also a regular speaker on employment-related matters, particularly for the Law Society of Ontario and the Ontario Bar Association. So for this session, instead of a formal presentation, we're going to have a panel discussion with our 2 speakers who will be answering a series of questions. Please feel free to pose any questions in our Q&A, and we will hopefully have a bit of time at the end to answer them. So without further ado, I'm going to pose the first question to Tatha, and it's a fairly lengthy one, so bear with me. Kara Zweibel, who is a lawyer with the Canadian Civil Liberties Association, said recently that an argument can be made that mandating vaccines is a violation of the Canadian Charter of Rights and Freedoms. She said, "It's a form of mandating medical treatment, and that is an extraordinary thing to do." On the other hand, an article published last month in the Canadian Medical Association Journal argues that it is legal to mandate healthcare staff, for example, to be vaccinated as a condition for work with some exceptions. So Tatha, can you clarify for us these competing perspectives? In particular, is a mandatory vaccination policy in the workplace context specific, so would only apply to high risk environments, or can any employer mandate and require vaccination as a condition for employment regardless of the context? And if so, what basis might they have for that?
Well, it is quite the question that seems to be on everyone's minds these days. And I think the key difference here is there between the 2 perspectives requires a little bit of unpacking, because when we're talking about mandating vaccines, we're not talking about the government forcing citizens to get this procedure or be fined or imprisoned. That would be a violation of the charter and of their civil liberties. Whether it's justified in that case is a different issue. But what we're talking about is not the state imposing the vaccinations, but employers saying to employees, you have to get this vaccine in order to come to work at this facility, or in some circumstances, keep your job even. And a person's job isn't a right or freedom that they're entitled to, like a civil liberty. An employer can't force you with state power to go and get the vaccine, but they can say there are certain consequences for your job if you don't get the vaccination. So the analysis is a little bit different between what a government can legislate and what employers can say in the workplace in terms of running the workplace. Secondly, the charter protects, Section 7 is what we're talking about here, life, liberty, and security of the person. And that applies to government action, not employer action, generally speaking. Hospitals are an extension of government, but they're not carrying out government functions like making law. They're providing a service, and they are a workplace themselves. So the charter doesn't apply to hospitals and the kinds of workplaces we're looking at in managing their staff the same way that it would to the government. But what is relevant actually is that the courts have recognized a common law right outside of the charter to an employee's privacy, bodily integrity, and personal autonomy. And so we see that in the workplace with regard to mandatory alcohol and drug testing and polygraph tests. And we're certainly going to see it in terms of vaccinations. So generally, employers can set conditions of the workplace in the workplace, except where it interferes with human rights issues. We're going to talk about that in a little bit, and interference with bodily integrity. And so where there isn't an issue of interference with bodily integrity, and that's what we're talking about here, forcing someone to get a vaccination and undergo medical treatment, the court's approach has been to weigh the concern of the employer, so health and safety in this case, against the right of the employee to be free from bodily intrusion, and to consider the context, like the extent of the intrusion, its reasonableness in the circumstances. So here, the employer's interest is health and safety in the workplace. It's also a duty. They have the duty to protect everybody in the workplace, workers, patients, anyone that comes in, and they can be liable to the extent that they don't, or if they let or they're accused of letting a disease into the workplace. Mandatory vaccination policies, I think, are most likely to be justified under this analysis, where the health and safety concern of the employer is high and obvious. So long-term care facilities, for example, the health and safety concern is the risk of death by COVID vaccine for residents at an extremely high rate. We've seen this happen. Other workplaces at risk would be hospitals, medical care facilities, where there's going to be vulnerable patients and people in the workplace that are more likely to suffer a higher impact of contracting the disease. And so these kinds of workplaces are more likely to have an easier time justifying mandatory vaccination policies because the health and safety concern is so abundantly clear. I think, given the outbreak and the seriousness posed to the economy and people's health, I think many workplaces, more than that, or possibly every workplace, could justify a mandatory vaccine at some point.
Okay, thanks. And just to follow up on that, some legal experts are claiming that vaccines will be like the legal issue of 2021, but courts in Ontario and elsewhere have largely sided with healthcare workers who have refused flu vaccines. So in your opinion, are there meaningful differences between the flu and COVID-19 that would make it harder for an employee to argue against a mandatory vaccination policy in their workplace?
Yes, there are certainly a lot of meaningful differences between what we're used to seeing as the flu, which is seasonal, and COVID, and its impact on this legal issue. There has been some litigation in the past few years by healthcare workers opposing flu vaccination policies that hospitals have attempted to introduce. Now, this litigation hasn't been in the courts. It's actually been arbitration of union grievances. So workers that are represented by a union have a lot more strength to bring these kinds of complaints forward and have them decided by a decision maker. And in these cases, the arbitrators, which are like judges in the union context, have sided with the healthcare workers in balancing the health and safety concern against the mandatory vaccination policy. And there are a couple that I think are instructive. The most prominent one is St. Michael's, which is St. Michael's Hospital and the Ontario Nurses Association. So the nurses had opposed a policy the hospital tried to implement, which was a vaccination or mask policy. So the hospital wasn't even trying to say you have to vaccinate. They're just saying you have to vaccinate or mask. And the arbitrator still said that was too far to go. But here's why. The arbitrator said this policy isn't reasonable because there's insufficient evidence of a problem to be addressed by the vaccination policy. The arbitrator said the policy isn't aimed at an outbreak. Well, here we know it's definitely aimed at an outbreak. They said that the flu wasn't transmitted. There wasn't enough evidence to show the flu is transmitted by asymptomatic workers or pre-symptomatic workers. We have lots of evidence to show COVID is transmitted by people who never have symptoms or who have minor symptoms, or there's a huge delay before the onset of symptoms. The arbitrator also said there wasn't evidence that the flu vaccine significantly reduced the transmission because sometimes it's off, they don't get the right strain. Here, we're constantly testing. We see the vaccines are reducing transmission, and they're certainly reducing intubation and death. So another difference. And actually just a union difference that the arbitrator pointed to was, in that case, the collective agreement, which is a contract that covers all employees, said the employees had the right to refuse the vaccine anyway. And that's not going to be the case in the vast majority of workplaces we're looking at who have never considered imposing a vaccine. And other cases or other factors I think that would be argued today if healthcare workers or any other workers tried to oppose such a policy is, I think, the increased rate of death and sickness as opposed to the common flu. The fact that it's overwhelming the medical care system right now and people are dying of non-COVID related issues because they can't get into ICUs. The extensive economic harm, the declared state of emergency by the government, restricting what even citizens can do. I think an arbitrator or courts can have no problem saying, yes, we'll let employers impose a mandatory vaccination policy because this comparatively is such a small step and it's really, justified given all of these different factors.
Okay. And Tessa, I guess on what grounds, if any, could an employee refuse vaccination? So we know that an honestly held belief in a conspiracy theory isn't going to cut it, but are there other grounds that might be permissible? And also, can employees expect to be reasonably accommodated in their workplace if they refuse to be vaccinated?
So yes, an employee could refuse to get a vaccination on human rights grounds. They're protected grounds like age, disability, religion, sex. There are several others. The one that's most likely to apply in the vaccination context is disability, though, meaning that the employee has a medical condition that would prevent them from getting the vaccine or endanger their health if they did. So the employee would have to provide their employer with proof of medical the medical condition and a recommendation that their doctor said, because it's a medical condition, we recommend you don't get the vaccination. Medical conditions that spring to mind would be immune compromising conditions where even the side effect, like flu-like side effects of the vaccination could pose a significant health risk to an employee. Or another one could be predisposition to blood clots, for example, because we're seeing in the news the risk of AstraZeneca being higher in terms of blood clotting, although it seems to be extremely low. So we don't want to, or employer would definitely want to scrutinize, I think, the medical evidence behind that. But so once the employer then says, okay, the employee says, I've got a disability, I've proven it, here's my doctor's note, and here's my doctor's note saying it's linked to the vaccination, then the employer would have to accommodate the employee. That is an interesting analysis, though, because they don't just, they would have to figure out what's a reasonable accommodation. A kind of accommodation could mean changing the requirement of getting the vaccination, or it could be some other change to the workplace conditions. And it might mean that the employer says, okay, you don't have to get the vaccination, you can return anyway. If it was a lower risk environment, perhaps, or if the majority of workers at that point were vaccinated. But the employer might also say, well, it means you can't return to the workplace, but you can work from home if that's a possibility until and unless you get the vaccination. Or if working from home wasn't possible, the employer could potentially say, you're going to be on a leave. Maybe it's paid, depending on if they have a short-term disability policy, maybe they could squeeze it under that. Or they might at some point say, you're going to have to unfortunately be on an unpaid leave. We'll keep you employed, but we can't have you work from home. Maybe it's not a kind of workplace where they could work from home, and until or unless, you get a vaccine, your medical condition clears up, if it's, a temporary issue, or until COVID-19 isn't posing the same kind of risk in our workplace. So those are different kinds of accommodations that the employer could come up with. It may not be the preference of the employee.
And Daniel, I don't know if you have anything you want to add just briefly before I pose a question to you, to any of the answers that Tatha gave.
Thank you, and thanks for having me. And it's nice to be speaking to a group from my hometown of Ottawa on this very important topic. Tatha made some excellent points. What you're often going to hear from me, and Tatha knows this from dealing with me, is more of an employee kind of bent and feeling like employers might be overstepping their boundaries in some cases. So my overall perspective on this is that if the government isn't going to mandate vaccines, why should employers writ large be allowed to? And that writ large is important, right? That there are going to be contexts where it's significant. Nursing homes are a typical and an obvious example, where you're going to see a lot more leniency towards policies that require vaccinations in some form or another than you would in a typical workplace, be it a factory, be it an office. And of course, Tatha made the point as well, and it's a good point, that there are going to be environments where something short of a termination or a forced leave of absence are going to be available. And what I think a lot of the litigation you're going to be seeing is allegations that employers overstepped their boundaries, and that there was a step taken that was more restrictive than it needed to be, more punitive, more harmful to the employee's rights, and that the employer didn't necessarily consider options short of stopping the employee's pay, which is going to be a major factor in these cases, or even not stopping their pay, but not letting them come into work, because the Supreme Court of Canada has spoken about the importance of allowing people to work, that it's part of their identity and so on. And so you're going to have those competing interests at play.
Okay. And just speaking of the different environments, as you know, there have been reports of frontline workers, particularly in long-term care facilities, retirement homes, who have been refusing vaccines. The Ontario government seems reluctant to impose a mandate, and instead prefers to merely, encourage staff to get vaccinated. From an employment law perspective, is there more that the Ontario government and employers can or should do to address the issue of vaccine hesitancy and refusal in the workplace?
Yeah, it's a very good question. So where I want to start with that is, there's another arbitral case, and the theme you're going to be seeing is that so many of the rules or the rulings that might apply to these situations are going to come out of arbitration cases. And the reason for that is unions have the means to bring these cases forward and not necessarily feel the need to settle them in the way that individual employees do. I would say something like 99% of cases settle. So many cases are going to come out of arbitrations. And one of those cases is a 2002 case from Alberta called, it's nicknamed the Flu Immunization Policy Grievance. So you can see how it's applicable to this situation. And the arbitrator who decided that case stated as follows: absent any contractual or statutory authority, it does not rest with an employer to require medical treatment of people who do not give their consent in the context of mandatory vaccination. And so that, I think, is a really useful means of considering the issue at play here. So, and that's not the only, the Chinook, that's called the Chinook case. The Chinook case isn't the only case that deals with contractual rights. So for me, if I'm an employer, I'm going to start with somebody's contract. And we have contracts, whether they're implied or explicit, with each one of our each employee. And if I'm acting for an employer, my recommendation is you put contracts in place with your employees requiring vaccinations. That way you have consent from the employee to get vaccinated. Now, this gets tricky, of course. If I have an employee who's been with me since well before the pandemic started, there's going to be a bit of it's going to be difficult potentially to get that employee to sign a new contract, which requires a vaccination. But certainly with respect to new hires, it's available to me as an option. But absent a contractual authority, if you try to impose a serious sanction on one of your employees as a company, for example, termination of employment for cause, and I'll talk about a not for cause termination in a moment, or a forced unpaid leave of absence, I think it's likely that a court would decide that that was a wrongful dismissal, and the employee would be entitled to severance in addition to possibly other damages in that scenario, because there was no implied or explicit consent given to the sanction that was imposed. So often the question gets asked is an employer allowed to impose this policy? Well, I think the easy answer to that is sure. Employers can, nothing literally stops an employer from imposing any policy. The question is, what is the sanction that's going to be imposed on individuals who violate that policy? And what are the courts going to do with that sanction, or an adjudicative tribunal, as the case may be? And so that's where the rub occurs in these cases. It's not about the policy itself. Courts don't strike out policies, generally speaking. They deal with the outcomes, right? And so hopefully it's a matter of being creative and coming up with solutions for what should be a limited number of employees who refuse to disclose that they've been vaccinated, which oftentimes will mean they haven't been vaccinated, but not always. But if the sanction is termination or some other form of unpaid, of forcing somebody to not attend work and not get paid, then simply put, employers aren't the COVID police. It's if the government itself won't impose a requirement for employees to get vaccinated, why should companies have that right? Clearly, the government's made a decision, and it may be because of the charter issues that Tatha very, very aptly summed up, isn't putting in a mandate that citizens of this province must get a vaccination. Then how is it possible employers can be allowed to do the same thing? That's where I have a very tough time. And if the answer is, well, it's because of the charter, well, I realize the charter doesn't apply to private workplaces, generally speaking, but the charter values sometimes do. And if the charter value would prevent a government from imposing this mandate, I just have a very hard time seeing how most judges would allow it from a workplace.
So then I guess what you're saying is it's a kind of a wait and see situation right now, because it clearly is going to be litigated before the courts soon, probably.
Yeah, in the reasonably near future. I mean, I can't wait till I can get my vaccination, but I realize that not everybody's going to share my view. And if somebody were to come to me as a lawyer and said my employer is forcing me or else I'm going to get fired, I would feel reasonably confident bringing that case forward. If it was a wrongful dismissal battle, I'd feel fairly confident in our position. I mean, obviously, depending on the context, right? There's no one size fits all approach for these things. An employee who can work from home, I mean, is on the complete other end of the spectrum as somebody who works in a nursing home, right? For so many reasons, and Tatha really well summed them up. I'm not going to go through them again.
So I guess then, is there any recourse for an employee, let's say, who experiences an adverse reaction to a COVID-19 vaccine, especially if it is mandatory, or who contracts COVID-19 in the workplace?
Well, those are good questions, but they're two different questions. So I'll handle them one at a time, right? So let's assume for a moment that there is a requirement to get a vaccination and I have an adverse reaction as an employee. Well, first of all, what's my adverse reaction? I mean, from what I've read, 99% of individuals, maybe probably way more than that, are going to have mild or temporary reactions, right? I spoke to somebody who got it recently. He said he got a fever. He was laid up until 2 p.m. the next day and then went away. He was fine. My understanding from the reading I've done is that's the experience that is probably on the worst end of the spectrum for the experience of most people who've been vaccinated. And it's not that uncommon with other vaccinations. right? I mean, I know I've gotten my kids vaccinated and they have adverse reactions. They don't feel that well that night, and then they're better the next day. And, I appreciate there's going to be a limited number of individuals who might have a worse reaction than that. But the question in every legal case is, what are the damages that you're claiming? What exactly is it you suffered, and how is it compensable? In other words, what did you lose? Right? Well, if I lost a day of work, I could claim that day of work, right? If I suffered some form of trauma, the judges are trained to determine how to compensate someone for the trauma they experienced. But if the trauma is limited to a mild or even severe fever that went away, then I think your best case scenario as an employee is you get some probably fairly limited damages for that. And otherwise, you'd have to call expert evidence. It gets very complicated at that point about A, what caused the adverse reaction, B, to what extent you got the vaccination because you were required by the workplace. These would be very complicated cases. And then the sort of separate question from that is, well, what if we don't really know the longitudinal effects of vaccinations, right? And that's a lot of the concerns, and a lot of the conspiracy theories are about, well, what are the long-term reactions? We haven't had a chance to test this over a period of 10, 20, 30 years. I mean, we have other vaccines. We have epidemiologists who can speak to the likelihood that happens. But I speak to people regularly who say, 20 years ago, I worked in a factory and I was exposed to toxic substances, and now I want to bring a case, and incredibly complicated, those kinds of cases. You're going to need numerous expert witnesses to speak to that. And I always say I feel for the judges in that case, because I wouldn't want to be the one who has to decide how the damages are going to get assessed in a scenario like that. But I wouldn't feel overly confident as the employee in that case either. And I mean, if 20 years from now I'm experiencing some adverse reaction and I want to link it to the vaccine I was forced to get, I mean, you're looking at something that's going to be very hard to prove. And then, sorry, just to cover the secondary point is, I think the other question there was if somebody contracts COVID-19 in the workplace. So, that's a scenario we're already seeing, right? And just yesterday, I had one of my employer clients call me about exactly that situation. And of course, there's, generally speaking, I think you're going to see a due diligence defense for most companies. So in other words, did we follow the requirement of health and safety legislation, in this case, the Occupational Health and Safety Act for Ontario, that requires you to take every reasonable precaution in the circumstances? So again, it's going to be context driven. If you're working, say you're a security guard, you're working with members of the public, you're working directly with other people, you're constantly coming into contact with others. Well, did you provide personal protective equipment? Were there fiberglass barriers? Did you give people the option of taking a leave of absence? These and many other questions would be asked in that scenario. And if I were doing an examination of some kind of a witness, I would be poking away at those issues and trying to figure out, well, was there anything that reasonably should have been done that wasn't done? But ultimately, I think if the conclusion is the employer did everything reasonable in the circumstances and the employee, still knowing the risks, got COVID-19 as a result of the appearance in the workplace, chances are there'd be no or very limited liability there. And then the secondary question is, well, what did cause the contraction? In other words, we go to lots of places, grocery store, people in our own homes, and our workplaces, you name it. I got to go through every day in my life to figure out how I might have contracted any disease I might get. And there's always going to be an open question as to, well, did I get it from the workplace? Did I get it from somewhere else? And I mean, short of there being an outbreak in the workplace that makes it more obvious that that's where it arose, it's not always going to be a clear answer.
Excellent. Okay. And Daniel and Tatha, as you know, asking an employee whether they've had, their vaccination or asking them to provide proof of vaccination, it triggers a lot of privacy concerns and considerations, particularly where you're asking people, for health information. So let's say an employer does implement some sort of vaccine verification program or policy. What is the best practice for ensuring their employees' privacy rights are protected?
Yeah, I mean, I think the starting point for this, and I'm going to be a little cynical here, privacy rights tend to be a little bit overstated in Ontario. I mean, you can ask Tatha the same question you'd ask me, and I suspect both of us would say we don't get approached a lot by employees about, oh, my employer violated my privacy rights. It doesn't come up very often. And
we give them very disappointing answers.
yeah,
ask.
that's absolutely right. Yeah, we do. They don't like to hear it. The problem is that privacy legislation has very little teeth when it comes to, or very, very, not very sharp teeth when it comes to actually creating damages that an employee can pursue, right? There are certain limitations on certain kinds of companies, particularly when it comes to healthcare disclosure of healthcare information. Certain municipalities have different rules, but on the whole, your average workplace, there's very little you can do for a privacy violation. That's not to say there's nothing that can be done. The courts over the last 10 years or so in Ontario have started creating something called torts for various privacy violations. A couple of interesting ones have come up in the last few years. The most well-known tort that was created is called intrusion upon seclusion. And that would occur in a scenario where information that was or ought to have been known was private was disseminated publicly. So it was intruded upon when it was supposed to be secluded. And there have only been a few cases that have analyzed this tort. And generally speaking, this is a common theme. I'm often amazed at how little gets awarded to somebody who can even prove that they've suffered a violation like this from a dollar standpoint. Often you're talking about less than 6 figures, which hardly justifies a complex legal action where you're spending tens of thousands of dollars on legal fees and going through what must be an incredibly stressful experience for the individual who's been going through it. And that assumes you win. So there isn't that much from a privacy standpoint that we as employment lawyers are going to advise an employee that they would take on. I mean, it may be that you bluster a bit and you make a lot of threats and try to get the employer to pull back a bit and get something out of it. But ultimately, your rights, unfortunately, and this isn't a prescription from me, but the rights are fairly limited in this particular province when it comes to that. And so what can an employee do? What can the employer do if an employee refuses to show proof of vaccination? They're limited. They're really limited, right? So, I mean, maybe there's 2 scenarios, right? There's either I got vaccinated and for whatever my reasoning is, I'm not going to tell you because it's not your business, or I didn't get vaccinated and so I don't want to tell you the answer you don't want to hear. Presumably it's one of those 2 scenarios there. So either way, there's a violation of a policy at that point. Now, the question, as I said earlier, is it a violation of a contract? So if there's a contractual duty to provide this information and that duty doesn't in itself violate human rights legislation, for example, well, then I'm in breach of contract and it may very well be grounds for discipline, including but not limited to termination for cause. But without that, like I said earlier, I think employers, what is the sanction you can impose? Well, you didn't comply with our policy. Now what? I'm going to call my employment lawyer and, hey, Jodis, so-and-so didn't comply with our policy. What do we do? Well, you can fire them. You're going to owe severance at minimum. You're going to owe severance for that. Likely, it's possible you could allege cause for termination. But like I said earlier, I think, and Tatha may disagree with me, I think that's a tough case to prove. I don't know. Tatha, do you disagree with me?
I think employers are going to want to know because it will help them put in health and safety procedures. Especially if there's an outbreak, it might be helpful to know who's vaccinated and who isn't, although I don't know that we really understand how transmission still works with the vaccination. But yeah, the question is, well, so employers, absolutely, they might ask. You can't stop them from asking. What if the employee says, well, I'm not going to tell you? Well, what are you going to do about it? Well, probably nothing. The employer's probably going to do nothing. Or what if they say, well, I didn't get it? Well, what are they going to do then too? Are they going to terminate? I mean, if you play it through, if they didn't answer, they say I didn't get it, or whatever, the employer doesn't like the answer, the refusal to answer, are they really going to terminate the employee? I think probably not. Could they? Probably. They could give them a severance package, the employer, and then the employee would basically fight over the amount of severance. Or maybe they would say, well, it's a human rights issue. I didn't get it because I have this medical condition. So it comes back to that analysis.
Mhm.
So I think it's an interesting question, but it has a pretty boring answer because I think employers aren't going to do a whole lot to make employees answer the question. And if they answer it in a way that the employer doesn't like, they still probably aren't going to do much either.
Well, and that's a really good point. And also let's remember, I mean, this is ultimately at its core a public health issue, right? Is it really about that particular workplace? Because ultimately there's a reason that we're still required to wear masks once we get our vaccination. And it's because my understanding is, and I'm no doctor, I'm no epidemiologist, but my understanding as a layperson is there's still a risk that I can pass along COVID-19 to somebody else, despite the fact that I've been vaccinated, despite the fact that I've gotten my second dose, and despite the fact that it's been several weeks since that point in time. There's a reason we require people to still take social distancing and other steps. And it's because others can still contract the disease from us. And obviously those are very important precautions to take. But given that we have those precautions, well, what good am I doing by threatening termination or terminating my employees for not getting vaccinated when it's not actually accomplishing what it's designed to accomplish? The goal here is herd immunity, if I'm not mistaken, right? And so we as a society want everybody to get vaccinated. It is in the best interest of everybody that everybody is vaccinated. And this is why it makes sense from my perspective that it be a government mandate and not a company mandate.
So just on that note then, are employers permitted to incentivize employees to get vaccinated? So, here's a $200 vaccination bonus or a box of Krispy Kreme.
I like that.
Well, I think that's what I thought of immediately too, as soon as you said incentives. It's like, oh, okay, well, we're going to give you, here's the carrot. But even before we get to that, I think that it's going to happen naturally. An employer might say, if you've gotten vaccinated, we're going to recall you. If you're on layoff, you go to the front of the line, not as an incentive per se, but just that's an appropriate response to keep the workplace safe. You maybe go to the head of the line in being recalled, so you get your job back, or you're allowed to now return to full-time hours, which might mean full-time pay, because you're a little bit safer to introduce into the workplace. So you naturally get greater employer benefits. So I think that is going to be just a natural incentive that happens, whether or not employers announce that that's the plan. Like, you get this and you'll be first. The other one is the lollipop. Here's your vaccine bonus of $200 or whatever amount. I think that employers have to be careful about that, because I can imagine employees saying, well, I can't get it. I have a medical condition. So you're actually discriminating against me by refusing, like, you're disallowing me to get this employment perk that I can't get because of my disability. That's a human rights violation. I think that's really the biggest concern that employers run up against when they say everyone who gets it can have this and those who don't can't.
I guess, Tatha, my question would be, what about, say, somebody goes on mat leave and they don't get a bonus for that year because they didn't work, whereas others who didn't take a mat leave, or sorry, I should say parental leave, it could be a pat leave, they do get the bonus. I mean, is that discriminatory in our view? Those are always tricky, right? And so I guess,
yes. Because you didn't work. Yeah, you didn't work for it because you couldn't have. Right.
So it's similar analysis. Yeah. There may be distinguishing features, but you see the same questions come up. Yeah.
Right.
So
and something like a mat leave and an earned bonus where there are certain performance metrics versus we're just going to ask you to go around the corner and get a vaccination, but you can't because of the medical condition. Like, I think there's a difference there in work being. I think the difference for mat leave is it's the work being put in.
Yeah, and I mean, look, it's maybe the better question is, should you get a sort of annual raise when you come back from your parental leave, right? Is that you're still you're a member of the company, right? And so I think that maybe that's the better analogy there than a bonus for which there's a specific amount of work or production targets that have to be met, whereas nothing stopped you from, you're still there, right? And
Yeah,
so, if one, I think if one of those is a human rights violation, the other could be as well. And certainly, I think employers are at risk. It's a matter of what's my preference? What risk am I?
yeah,
Life is all about risk tolerance, right? And
yeah,
we're
yeah,
so often advising our employer clients, saying, "Well, you can do this. There is a risk. Chances are nobody calls you on it. Just law of averages."
yeah. I think my kind of final thought on it is that I look forward to the day that employers put incentives out there, because the vaccines are so available that it's really a live issue. Because right now, not we can't all get them, and so it's very hard for an employer to say, here's your incentive, to some who can't, some who can get it, some who can't get it, and the majority not being able to get it right now.
I think the best example of where we're seeing that is in the sports world, where they're being told if 85% of your team gets vaccinated, you can go out for dinners again, and start enjoying your life and not feel like prisoners in a hotel. No, that's a really interesting carrot to dangle in front of, and then it creates this peer pressure on saying, oh, we're only at 80%. Well, Matt Sundin, you go and get your vaccination. We'll be over 85%. And a lot of this will be peer pressure. Absolutely. And if I would be inclined to try to create those scenarios if that was my objective as a workplace.
Yes, and I think, Dan, you said on another program that people are going to make themselves potentially unemployable by not getting it. The more people get it, you're now making yourself an outlier who could be, who's seen outside the norm. And I mean, it's a highly competitive job market. Is that what you want to be doing right now? Just making yourself less employable.
Thanks, Tess and Daniel. We're going to move on quickly just to some Q&As that have been posed in the Q&A function here. And the first question is from Basha, and she asks, do employers running private organizations for people with disabilities have more discretion, particularly if they have problems retaining staff? And I would assume more discretion to create, a mandatory vaccination policy.
So just reviewing.
Sorry, could you say it one more time?
Yeah. So do employers running private organizations for people with disabilities have more discretion, I guess, to create, a mandatory vaccination policy for their staff?
I think I'll touch on that quickly. I mean, it will depend on what sort of disabilities we're dealing with, right? I mean, and I mean, I say that with all due sensitivity. I've heard of examples where people with certain mental health disabilities might have the right to get a vaccination before somebody who doesn't have that, right? And so it's not necessarily going to be a matter of physical versus mental disabilities, because, as employment lawyers, we're very attuned to that. We deal with that with great frequency. But I think it's going to depend on the context of what sort. It's a great question, and it's going to depend on the context of what sort of disabilities you're dealing with, and what is the nexus between those patients or those individuals and the vaccine for people who work there, right? Like, what is the connection? It's not going to be as simple as, oh, well, these people are particularly sensitive, so you should get vaccines. There's got to be a logical connection, I would think.
Yeah. Is it a higher risk workplace? Becomes the first question, and depending on the type of disability, it might be very much yes, or no.
Okay. So the next question then, if an employer cannot mandate, vaccination policy in the workplace, can they at least mandate COVID-19 testing as an alternative that would be mandatory?
I think they can I think they do mandate it already in response to a concern about an outbreak, to say, if you think you might have COVID, or you have a symptom, we do require that you go and get a test, and then you can't return until you get your negative test. But I think maybe this question might be a little broader. Like, can we mandate that everyone gets it every Monday, or random testing? And I think that there's going to be more of a problem if the mandate to get the testing isn't targeted at someone who has symptoms or a reason to believe that they might have COVID. I think that an employee would validly say, I shouldn't have to get tested every Monday, every Tuesday, or just randomly. But I think I am aware that there are film sites are actually doing that. They are doing, because they're all, you know, in close proximity, they are doing 2 tests a week. I know someone actually who's a producer, and that's what they require on that site. That wouldn't be most workplaces where we're all wearing masks and we're not in scenes where we're you know, up close to people.
Daniel, do you have anything to add to that?
No, I mean, I would just say that I know it's a little bit slightly off the topic, but I mean, certainly we've talked about, it would be fabulous if there could be a priority put on those who deal directly with children who, as noted by the question, can't get vaccinated at this time, that they get priority for vaccination options, at least to have the option to have the vaccine. And then the more difficult question, of course, is, is it easier to require them to get the vaccination? And I think the answer is, you're going to have an easier time requiring it there. It's still going to be a matter of how are the courts going to handle it, and are they going to handle it in the same way as flu vaccine precedents? And the answer, to Tatha said, is probably not. There's a lot of distinguishing features there.
And the final question for our presenters. So let's say even if you are vaccinated, can you still be able to request working from home, particularly if even as a vaccinated person, you still have concerns about going into the workplace?
That's a good question. So, sorry, I don't mean to step on your toes, Tatha.
No, go ahead.
Okay. So, I mean, I think we're going to see a lot of these problems coming up where we've all become accustomed now, or at least a lot of us, myself included, look where I am right now, to working from home, right? And there's going to be this reworking, recalibration of workplaces in terms of where does the work have to be done now? Has the employment contract implicitly changed to allow working from home? And the question is, there's no sort of, we're not going to snap our fingers and one day COVID's over. It's gradual. So at what point can we force workers to come back to work? And am I going to have a policy in place where I say to all of my workers, okay, you got vaccinated, you come back, but everybody else, you can stay home, right? It's going to be done on a case-by-case basis. But I don't think it's unreasonable, short of there being a medical explanation for the need to stay home from a medical standpoint, to say, I'm not coming back into the workplace any longer unless my workplace is now my home, or unless I have a contract that allows me to work from home. So I think that you're going to need, if your employer tells you, you must come to work, and your answer is, I don't want to, then you better have a legitimate explanation from a credible, presumably not always medical source, as to why you require accommodation to work from home. Mm-hmm. And it may be that part of the answer is, well, yeah, I've been vaccinated, but X, Y, and Z, for these reasons, I can't come in, or at least I can't come in for the time being.
Yeah, I think the employee is going to have a tough time saying, I'm concerned about coming in because I'm going to get it, and I'm going to probably get at most a mild to medium reaction, like I'm going to get a regular flu. Is that dangerous enough? Is that a big enough danger in the workplace to say I'm legitimately concerned? I think probably not. More likely, the employee would have a stronger case, I think, if they said, I'm taking care of my elderly parent who is predisposed. Yes, they're vaccinated, but they still could they could still have an adverse reaction here, or I have an immune compromised child that could not get the vaccination. I think they would have a strong argument. But if it's just the employee's concern about not getting a case of the flu, assuming that is now what's most realistically going to happen if they're vaccinated, and I don't think they're going to have a strong case to keep their working from home arrangement.
Yeah, I mean, that's a good point. Employee preferences, we hear them all the time. And sometimes when you unpack what an employee tries to claim is an accommodation measure, it's really just what they want. And there's no need under human rights legislation to accommodate employee preferences. There's a requirement to accommodate prohibited grounds under the code.
Okay, on that note, we are going to have to end the discussion, but Tath and Daniel, thank you so much for taking time out of your busy schedules to share your expertise with us today. We really, really appreciate it.
Thank you for having us.
Thank you.
That was really fantastic. Thank you. Thank you to Tatha and Daniel and to Liz for that last session. There were a lot of questions, not only in the last session, but the one prior that we were not able to get to. So please remember just to give us, send us an email if you have further questions, and we'll try and answer them for you. And again, we also have this resources sheet that is posted on our website, and we'll also be sending it to you after the event. So please take a look at these resources. They've been curated by Alexandra and Liz and our student that's been working with us on some of the various organizations that can help, that can provide resources and information for your clients. So we've now come to the end of our day very quickly, and we want to thank you for your participation. Alexandra, Liz, and myself would like to thank our speakers, foremost, our funder, the Law Foundation of Ontario, and again, Community Legal Education Ontario for their support with this event today. We've never done a webinar before, and we really want to thank Cleo and especially Urush, Michelle, Karen, and Brenda for all of their help and their support with this. We also want to thank Beth and Glenda from the Canadian Hearing Society for providing the ASL this afternoon. And finally, we want to thank you for coming on again, another Zoom call for this education session today and supporting this virtual event. We are hoping that next year we'll be able to have an event where we can all get together again and network in person. But thank you for your patience. Thank you for your attention. Thank you for your support of Connecting Ottawa. There'll be an evaluation sent to you probably on Monday, along with a copy of the resource sheet. And we really encourage you to fill it out and give us feedback, not only on this event, but other events that can help you to support your clients. So just a reminder that Connecting Ottawa is available to answer your questions, to support you with any client legal issues, and we've put the contact information there. And if you haven't done so, please check out our relaunched Connecting Ottawa website. We're very proud of it, and there's a lot of great resources on there. So with that, the three of us, our team, will say thank you and have a good afternoon. And we look forward to the time that we can actually talk to you in person. So have a great afternoon, everyone.
Have a great afternoon. Take care.